let us start out with that. So here, oh gosh, where is my English? There's English. Here we have the sources of education law. There are various sources of all of these colored blocks. Each of them represents a source. We have different forms of law. We do not work with these ones on the side in this module. We work with legislation and a little bit with common law and a little bit with case. So those are, someone has a mic unmuted. Would you please mute? Because the background noise is a bit distracting. Okay, so thank you. All right, so we have legislation, we have common law, and we have case law. What I want to emphasize today is that legislation has a specific hierarchy. Let me just see. So here I've put down a triangle to just indicate that there's a hierarchy in terms of how much say or how much authority a legal document has. So in the top of this, we have the Constitution. The Constitution has the highest authority in South African legal system. Nothing else, no other legal rule may contradict the Constitution. Everything has to be in line with the Constitution. So in this diagram that you see in front of you, you have the blocks with single lines, and then there's the blocks with double lines. So we have, in South Africa, we have the legislature, which is Parliament and the provincial legislatures, and they are responsible for making laws, which we call acts. So those acts, we call them original legislation because these bodies are the original legislators. They got their power to make law from the Constitution. So the Constitution grants power to Parliament and to the provincial legislatures and to the municipal boards. And those bodies each have the right and authority to make certain legislation. And that legislation, when they make it, we call that original legislation. Oh, sorry. I clicked on the wrong button there. Okay, so first of all, if Parliament issues acts, they are parliamentary legislation, or we call one an act of Parliament. And then we also have provincial acts. So nationally in South Africa, we have, for example, the South African Schools Act. And then together with the Schools Act, which is obviously one of the most important acts for education, we have three other acts that is important for education. We have the National Education Policy Act, we have the Employment of Educators Act, and we have the SACE Act. So those four acts are important parliamentary legislation, which we have to take note of in education for South Africa. And then a province, each province may then also create some laws. And you know the difference by, if it's national, it doesn't have the name of any province in. But if it is a provincial law, it will have the name of the province. For example, Gauteng School Education Bill is an example. So you know that it's provincial legislation by the fact that it has the name of the province in the title of the law. And then about municipal legislation, you don't have to worry too much, but it's important for governing bodies and school principals because it deals, among others, with things like electricity, building regulations, sanitary regulations, and so on. Okay, then these original legislation in the acts, in this module, we work mainly with national legislation. We are not going to concern ourselves with provincial legislation, because when you start working, you will be in a province and you will become aware through your principle of your province's specific legislation. But basically, national legislation is applicable everywhere in the country, not only in particular provinces. So when we look at the subordinate legislation, the blocks that are have double stripes around them, they are issued not by original legislators. They are issued by the executive. So who is the executive? Executive is the part of government that actually does the day-to-day governance of the country. So they have to make sure, in the case of education, that education actually takes place. And in South Africa, that is in the form of the Department of Basic Education, and we also have Department of Further Education and Training. In the case of school education, the Department of Basic Education is tasked to implement the education laws and make sure that education rights are realized. And there, on national level, we call it subordinate legislation. And that includes things that the Minister of Education has made available in the Government Gazette, such as regulations for safety measures. There are some guidelines, there are some norms and standards, there are some national policies. So those documents are subordinate legislation issued or promulgated or made available by the Minister of Education or the Department of Education on a national level, and that is subordinate to original legislation. In other words, has a lower rank in terms of authority, and it may not be contrary to what is in original legislation. So subordinate legislation must be in line with original legislation. Why do we have this? Usually, an act, for example, the Schools Act, is very general in nature. It gives general indications and rules and principles. And then the executive, the Department of Education, now has to make that a reality. And in order to do that, they must come up with some specifications of how, when, where, and who will be responsible for what. And to do that, they will issue regulations, norms, and standards and guidelines for the very different, all of the different sections and functions. Oh, sorry, all of the different functions in the education department. And that usually gives a lot more detail. So, for example, the norms and standards for school infrastructure explains how a school should look, what should be on the school grounds, how many classes per learner or how many learners per class, and so on, toilets and all of that things. The regulations for safety measures at public schools, that tells us all about safety. And then the national norms or national policy for language tells us all about how language should be managed in the schools. And so you can go on and on. For every function, basically, there will be a form of subordinate legislation issued by the Department of Education that tells us in more detail how the functions given in the Act should be made a reality in the day-to-day functions of the education system. And then again, we have the same thing on provincial level. So each province might add some more detail of who are the functionaries in that specific province and what are the procedures and the processes in that particular province. But in this module, we are going to look at our national original legislation and our national subordinate legislation. And then something that is also very important is the school-based subordinate legislation. In our Schools Act, the governing body of a school receives the power to adopt specific school-based subordinate legislation, such as the Code of Conduct for Learners, the admission policy of the school, the religious policy of the school, and the language policy of the school. So those are important documents that regulate the functions, those functions within the school on a very contextualized grassroots level. And it's supposed to be done by the governing body in a way that accommodates the needs of the immediate community of the school. So those documents we call school-based subordinate legislation or school-based policies, and they are also important for the sake of this module. All right, let me pause there and see whether any of you have any questions in this regard so far. If you have a question, you can go to reactions and raise your hand. Any questions about the legislation? Are you comfortable with that? Bungeka, do you want to ask a question?
No, ma'am.
Oh, okay. All right, so let me continue. So when we read and interpret legislation, it is important to remember a couple of principles. But before we go there, I want you to take your statutes in your hand, or if you don't have the statutes, you will use the documents that I have placed under the resources for you. So let me just go to one of my own documents. Okay, let us start with the Schools Act. So if you have statutes, someone's mic is open, it creates some disturbance. Please just mute.
Hopefully. It's fine. It's not even.
Okay, you should mute, please. All right. Okay, so if you have statutes, look in your table of contents on which page you will find the start of the South African Schools Act, and then you go to the first page of the South African Schools Act. If you do not have statutes, under the resources for Ifundi, which I've placed there for you, please just open the document called South African Schools Act. Can you see mine on my screen?
Yes, ma'am, we can.
Thank you. All right, so let us go through and I will show you different sections of an act. So most acts have more or less the same pattern, or the same format. So first of all, you will see what we call the short title of the act. So in this case, it is South African Schools Act 84 of 1996. So that is the short title. When we reference this act or we cite this act, we will use this South African Schools Act, and we will write that number and that year, that date. So this means that in 1996, this was the 84th act that was enacted by Parliament. Then it will show you when it was accepted by Parliament and when it came into practice. So although it was accepted in Parliament on 6 November, there was a little bit of a grace period for the Department of Education and people to just make themselves ready for this new law that came out. So it commenced on 1 January 1997. You will see it shows that the English text is signed by the President. So, often legislation is translated into some of our other official languages, in which case the President will sign one of the languages. And if there's any dispute regarding differences in the language of, say, for example, the Afrikaans and the English version, the one that was signed by the President will be the final, will have the final word. So in this case, if there's difference between South African Schools Act and Suid-Afrikaanse Skolewet, then the English text has the last say. All right, and then there is a list that says as amended by. So amend means to change. So often from time to time, Parliament will change or make changes to the Act to bring in new things, maybe new developments, maybe new rules and principles and so on. And then Parliament will issue an Education Laws Amendment Act. And in the Amendment Act, it will indicate which parts of this whole document must change and in what way. Sometimes a wording is changed, sometimes a new provision is inserted in between the others. Sometimes a provision is totally removed or deleted. So in this case, what is important to know is if you see that this document that you have in front of you has been amended or has taken into account the amendments made by all of these different amendment acts. From 1997 up until 2007, it has been updated up until 2007. So it is important if you read and take note that by the time that you enter practice, not next year, the year after, there would have been a new Education Law Amendments Act. There is currently one serving in Parliament. So probably it will be assented this year or next year. So by the time that you are a teacher, then you will know that this copy of the Schools Act is not valid anymore because it doesn't take into account the 2022 or maybe the 2023 Amendment Act. So that is why it is important when we have a document to know, is this the most recent copy or the most recent updated copy of the Schools Act in this case? Okay. And then it tells us that there are certain regulations. Remember that I just told you about subordinate legislation. So regulations are a form of subordinate legislation. And it names 5 different legal documents that got its authority from the Schools Act, which the Minister of Education has issued under the authority given by the Schools Act. And then you will see there's a little paragraph, usually printed in bold. So there's the word Act. And then it says to provide for a uniform system for the organization, governance, and funding of schools, to amend and repeal certain laws relating to schools, and to provide for matters connected therewith. This paragraph we call the long title. So this one is the short title, but this one is called the long title. And the long title of an act, each one has one. The long title states the purpose or the goal or the objective of the act. Most acts, not always, but most of them have a preamble, which gives a little bit background. Why, where did this come from? Why do we need this act? Why is it important? And what are the values that underpins the law that is made in this act? So that is the preamble. Long title, preamble. And then below the preamble starts chapter 1. So the acts are divided into chapters, each chapter built around a certain topic or theme. Usually, the very first section in an act will be definitions, and I will explain that to you just now. And then we have several chapters in this act, in the Schools Act. Chapter 2 is about learners, so everything related to learners you will find in chapter 2. And then, let's see, where am I now? Still chapter 2. There's suspension, so you will see there's a number of topics related to learners included. There's the start of chapter 3, which is all about public schools from sections 12 to 33. And then mute, please. See who's making a noise. Not careful. Okay, then you will see there's chapter 4, funding of public schools. And so it goes on. There's a couple of chapters, if I remember correctly, there are 6. So whenever we have a question, say, for example, we want to know at what age should learners go to school? Then we will think, okay, South African Schools Act is probably where we will find the answer. And we will look at the headings of the chapters, which luckily, if you have statutes, you have a table of contents for that. And then we will say, well, probably if we're asking when will learners have to go to school, it will probably be in the chapter about learners. If we want to know something about school funds and how much school fees we can ask and how we can enforce the payment of school fees and so on, we will probably look in chapter 4 about school finance and so on. So that the chapters help us to know where to look for the answer or the rules that we need. Okay, then let us get back to the definitions. In law, and when we interpret legislation, usually we use words in the normal sense of the word. So parent means parent, constitution means constitution, learner means learner. But often in law, definitions are very specifically demarcated. So it includes something and excludes something, or it includes some extra that we don't normally include in our day-to-day way of talking. Let's see, for example, educator. Educator means any person, excluding a person who is appointed exclusively to perform extracurricular duties, who teaches, educates, or trains other persons, or who provides professional educational services, including professional therapy and education psychological services at a school. This is how an educator is defined in this act. So whenever we read the word educator in this act, we know it includes all of this and excludes people who do extracurricular duties exclusively. They don't teach at all, they just teach extracurricular. So that is important to know, that when you read something in the law, you must check the definitions to see whether you have the definition right. I like to also point out the definition of parent, because there is a lot of duties and responsibilities that the Schools Act places on parents. And the Schools Act also outlines the role that parents should play in their children's schooling. And in this case, it includes biological and adoptive parents. It includes the person who has legal custody. But then, take note of C, it also includes the person who undertakes to fulfill the obligations of a person referred to in A or B. So if a child is living with a grandmother or a grandfather or an older brother or sister or an auntie or someone else, that person is, for the sake of this law, the parent and not the biological or the adoptive parent. So it is important to take note of the definitions to see how the law defines specific words. Not all of the words are defined, but there are some words that are specifically defined, and it might also differ. For example, in the Schools Act and in the Employment of Educators Act, the definition for educator is not the same, because there are some exclusions for the one and some inclusions for the other. So when we read the Employment of Educators Act, we use that definition. And when we read the Schools Act, we use the Schools Act's definition. Okay, so then let us look at how we read and interpret and cite the law. So you see these little number and a heading. So all of the paragraphs under this heading is part of section 3. So there's section 3. Here we have section 4, it has 2 paragraphs. Then we have section 5 about admission to public schools, and it has quite a number of paragraphs. You can see that it's very long. We have section 6, language policy of public schools, and it has 4 paragraphs and so on. So the entirety of all the paragraphs together is referred to as a section. In this case, it is section 6. If you see it like this with a capital letter 6A, it means that is the number of it is 6A. And there is 6B. So what happens is originally we had sections 1, 2, 3, 4, 5, and so on. And then when the Amendment Acts came and they wanted to insert new sections, they didn't want to renumber all of the sections. So they just added an A and a B. And then we have section 7, and we have section 8. I don't know, is 8, there's section 8, sorry, there's section 8. And then the same happened with 8. We also have 8A, which was inserted afterwards a couple of years later. Okay, so that is a section. So let us go back to one that's not very long. It makes it a bit easier to read for now. Okay, let's take section 6. Section 6 has 4 paragraphs. These paragraphs each have a number in brackets. Sometimes it will be an alphabetical letter. These are the 4 subsections of section 6. So then you will refer to section 6 and subsection 1 for this paragraph. If you want to refer to this paragraph about sign language, you will say it is section 6, subsection 4. And when we write it down, we write a 6 bracket 4 close bracket, then with section 6, 4. Okay, so these are the subsections. And then in this example, often there are subparagraphs to one of these subsections. So in this case, it is a subsection, and A and B, these two, will be the subsections. And then when we cite it, we will write 6A, bracket 1, close bracket, bracket A, close bracket. So every level gets their own set of brackets. It's just the original section number that is not in brackets. We also have subsections. I saw an example just now, like here. There is subsection 5 with a subsection A, and then it has subsections, Roman 1 to Roman 6. So in this case, you would write section 8A, bracket 5, bracket, new bracket, A, close bracket, new bracket, I, close bracket, to refer to this little section of the name of a learner in whose possession it was found that has to be correctly labeled on a dangerous object or an illegal drug that has been seized from a learner at school. All right. So when we read subsections and subsections, usually they form part of the whole of the subsection. So for example, in this case, 8A, 2. Oh goodness, sorry. Has subsection A and subsection B, which means that these little parts form part of the sentence beginning here. So you don't read these as loose standing. You read them together with, shall I call it, the mother sentence. So this would be the mother sentence, and then these are the babies. And you cannot separate the babies from the mommy, they will cry. Okay, so you will read subsection 3, the principal or his or her delegate may, at random, search any group of learners or the property of a group of learners for any dangerous object or illegal drug if a fair and reasonable suspicion has been established that a dangerous object or illegal drug might be found on school premises or during a school activity. So that is one sentence. Or if you want to understand this little part with B, you start again for the mother sentence. Subsection 3, the principal, his or her delegate may, at random, search any group of learners or the property of a group of learners for any dangerous object or illegal drug if a fair and reasonable suspicion has been established B, that one or more learners on school premises or during a school activity are in the possession of dangerous objects or illegal drugs. So basically, that is how we read. So the little baby sentences of the subsections and the subsections form part of the whole of a subsection, and the various subsections form part of the whole of a section. So sometimes it's necessary to quote one little piece, and we can do that. But sometimes when we want to explain something, it's necessary to put it into the context of the entire section. It can be dangerous to take out a small little piece out of the context of the entire section because they are grouped together for a reason. Usually the various subsections will cross-reference one another, and it's necessary to understand them together. Like in this example, because it says subsection 3, and there is subsection 3, which means that subsection 3 gives us a rule that we have to apply when we search learners for dangerous objects or illegal drugs according to subsection 2. All right, let me pause here and give you opportunity for questions. Are there any questions from your side? Were you able to follow with me on your documents? I sure hope so. Any questions, guys? No questions. Okay, so let us go back to the PowerPoint, and I'm going to show you how to cite, read, understand, and cite. And then you are going to do an example. So please get your documents ready, your statutes, and also please have a pen and paper. So when we read, remember that each word bears a meaning. So we are not allowed to leave out words or read into the law words that is not said. And then words bear their ordinary meaning unless they are specifically defined in the Act. Then when you read law, you must take note of words like must and every and all, and then also words like no or may not. These are words that gives a clear authoritative provision, like this must be done or you have to do it. But if there's a word like may, sometimes the word may is used, it means that the person who is, for example, the manager, the school principal, if it may do something, then you may use your own discretion. You don't have to do it. But words like must and every and have and so, that means it's a definite must. You have to do it. Okay, and then don't make any additions and don't leave anything out. All right. So I have shown you all the different sections of an Act. It is also in the PowerPoint if you want to just go over it again later. And then let us do an example. All right, so I want you now to go to the Employment of Educators Act. I want you to go to section 11, subsection 1, subsection E of the Employment of Educators Act. See that you can follow with me and see how we have dealt with the citation from that act. So I have mine on the screen, Employment of Educators Act. So remember, this is called short title. Oopsie. That is the short title. That is the title of the Act. And that is what we're going to use when we refer to the Act. So I have a question. The question is, may educators be discharged on account of misconduct? So you are an educator and maybe you have done something wrong. And now your principal tells you, you are going to lose your job. I'm going to fire you. And you want to know, may that happen? Is that something that can actually happen to you? Then we go to the Employment of Educators Act because discharge of a person who works or is an employer or employee is probably found in the Employment of Educators Act, because this act provides for the employment of educators by the state, for the regulation of conditions of service, for discipline, retirement, and discharge of educators and matters connected therewith. So the long title already tells you what this act is about, which will help you identify which act you need to look for the answer. Okay, so if we go down this act, we can see there is termination of services in chapter 4. Oh my gosh. And discharge of educators are dealt with in section 11. So let us scroll down to section 11. So please take your statutes and go with me to section 11 so that you can make sure that you are able to find it and understand how to work with your statutes. Okay, there is section 11, discharge of educators. And it says, subsection 1, the employer may, having due regard to the applicable provisions of the Labour Relations Act, discharge an educator from service, and then it has subsections, A to G, which gives reasons or incidences in which an educator can be discharged. And there is ill health, there is post-reduction, there is incapacity, there is unfitness for the duty, and then E is on account of misconduct. So if you were wondering, as an educator, if you are guilty of misconduct, can you be discharged? The answer is yes. So how do you write up this answer? You write yes in terms of, or you can say according to, it means the same thing. And then you have to write down the numbers of the section or the subsection that you are citing. In this case, 11, and in bracket 1, close bracket, this is the subsection, and then another bracket, E, close bracket, this is the subsection. Let's just see how it looks again. There is 11, can you see it? Let's just make it a little bit. 11, subsection 1,
Ma'am,
E. Yes.
you didn't share your screen. It's not showing. I only see your face.
Oh my gosh. Oh, thank you. Okay, let me just start over with that one. Excuse. Okay, share screen. Oh, yeah. Okay, sorry. So let me just start again at the top of the Employment Educators Act. So there's the short title of the Act. And in the long title of the Act, we can see that the discharge of educators is part of what this Act provides for. If we look in the table of contents, we find termination of services and discharge of educators in section 11. So then we go down to section 11. And there we read the section 11, discharge of educators, subsection 1, the employer may, having due regard to the applicable provisions of the Labour Relations Act, discharge an educator from service, and then E, on account of misconduct. So when we cite that, it will look like this. We say yes. In terms of section 11, subsection 1, subsection E of the Employment of Educators Act 76 of 1998. So let's check in the Employment of Educators Act 11(1)(e). And in our citation 11(1)(e), and note how each level of subsection and subsection has their own brackets. And then you have to include the title of the Act. In this case, the short title is the Employment of Educators Act 76 of 1998. And you, oh gosh, that's the wrong one. And you have seen that at the very top of the Act, Employment of Educators Act It was Act number 76 of 1998. And then you must say what it says. What is the provision there? It says educators may be discharged on account of misconduct. Therefore, an educator may be dismissed if found guilty of misconduct. And then you have your answers to your question. So this is an easy example, sometimes still a bit more complex. Sometimes you need 2 or 3 different provisions from the same act to arrive at an answer to a question. And other times you need different sections from different pieces of legislation, different acts, to arrive at an answer to the question. So now I want you to do the same with this question. May the parent of a learner administer corporal punishment to an unruly learner at school? So say you have a grade 2 class and you have one little learner who is really giving you a lot of trouble, and you have phoned the parent and the parent says, you know what, you got to hit my child is used to being hit, and if he's not getting corporal punishment, he will just not listen. There's just nothing else that works for my child. And then you think, okay, well, I know that teachers may not administer corporal punishment, but what if I have the parent come to school and give the child corporal punishment at school? Is that allowed? So please go to your Schools Act and find the answer to this question and then write it down in the format I've shown you. So you have to write, oh my gosh, you have to write yes or no, and then you have to write in terms of and the relevant sections, and then you have to write the title of the act and then your answer. So please find the answer to this question in the Schools Act, and you can do it now. Let us take 5 minutes, and then in 5 minutes time, I will show you the answer. Okay, 1 more minute. I hope that you are getting there. You are welcome to ask if you're struggling. Okay, are you done? Let's see our question. May the parents of a learner administer cruel punishment to an unruly learner at school? And we are looking in the Schools Act because we have seen that that regulates everything to do with the school and the learners. In this case, you probably found section 10, which says prohibition of corporal punishment. And we need to understand what it says and what it involves. So it says in subsection 1, no person may administer corporal punishment at a school to a learner. So what does that mean? May the parent administer corporal punishment at school to the learner or not?
No, ma'am.
Correct, they may not. So you will write no. And then in terms of section 10 and with brackets, subsection 1. So let's just see again in the act, there's section 10 with 2 different subsections, and we are referencing subsection 1. So in terms of section 10(1) of, and now you have to quote the short title of the act, which is given at the top of the act, South African Schools Act 84 of 1996. So there you have the short title in full with the number and year, and then you will say no person may administer corporal punishment to a learner at a school. Thus, when the learner is at school, not even their parent may administer corporal punishment. All right, so we have the answer to our question. So the 2 examples I've done now were fairly straightforward. The key words of your answer was in the heading of the section that we used. But sometimes the answer, sometimes the answer is not that obvious from the headings of the section. Sometimes we have to actually go and read some of the content of an act to find the answer. So let us do one example from the Constitution, which is less obvious and less easy. And it says, the question is, which rights of the learner are infringed when an educator punishes a learner by prohibiting the learner from using the toilet? So we are talking about rights, and that is why you will look in the Constitution, chapter 2, the Bill of Rights. And then a key word that I can hint you towards is the word punishment or punishes. So let us look in the Bill of Rights for something that has to do with punishment and how punishment and rights interact with one another. And then let's take 5 minutes and see if you can find the answer to this question and write it up in the correct way as I have shown you. Okay, so let me hear from you. If you know which right has been infringed, you can raise your hands and tell me. I hope you found it. Anyone who knows? Ina?
Ma'am, is it the right to freedom and security of the person?
Perfect. Yeah, that is. Let me show you, and then you can check whether you have written it up in the correct way. So there, we said the question is which right of the learner is infringed when the educator punishes the learner by prohibiting the learner from using the toilet. So the answer is the right to freedom and security of the person. In terms of section 12, subsection 1, subsection E. Let's just see how it reads in the Bill of Rights. We have section 12 here, freedom and security of the person. And then you see we have two subsections or paragraphs, and subsection 1 has A, B, C, D, and E as subsections. So remember that we now have a parent sentence, and then we have the baby sentences that belong with the parent. In this case, you have everyone has the right to freedom and security of the person, which includes the right not to be deprived of freedom, arbitrary or without just cause. That's not applicable in this case because that is all about detaining someone or taking the freedom away. Then B is not to be detained without a trial. C is to be free from all forms of violence from either public or private sources. And if it says all forms of violence, it can include emotional violence. Then D, not to be treated in any way. And E, not to be treated or punished in a cruel, inhumane, or degrading way. So you can make an argument for a form of violence, emotional violence, maybe. You can make an argument for torture, but usually we take the one that seems more straightforward and more directly relevant, and we leave out those who are maybe remotely relevant. So in this case, not to be treated or punished in a cruel, inhumane, or degrading way is directly relevant. So we have section 12, subsection 1, and subsection E. When we write up, we will write 12, bracket 1, close bracket E, close bracket. And then we have to write the name or the title of the document. So you have seen that in the previous examples, we have written the number and year. But the Constitution is a little bit different. The Constitution is special in that way. We have only one Constitution. There can be no confusion about different versions of constitutions. And also the Constitution has special character and authority in South Africa. It is its supreme law, and therefore Parliament has decided that we don't include the year when we refer to the Constitution. We only say the Constitution, and we give, we don't include the number, we include only the year. So when we cite, you will see, let me just see if my document of the Bill of Rights is complete. It is the Constitution of the Republic of South Africa, 108 of 1996, but we leave out 108 of because the Constitution is special. So that's the one thing that we do differently with the Constitution. So even though this is the correct full title, we will write the Constitution of the Republic of South Africa, 1996. And then you have to explain your answer. What does it say and how does it relate to your question? So we will say in terms of section 12(1)(e) of the Constitution, everyone has the right not to be punished in an inhumane or degrading manner. Withholding someone from using the toilet could be seen as degrading at least and even inhumane. Therefore, such punishment would violate the learner's right in terms of section 12(1)(e). So your answer doesn't have to be exactly word for word the same as mine. Also take note of how we cite and what information we include. I didn't include a direct quote. You can choose. You can include a direct quote and use word for word the words exactly as they occur in section 12. But what I have done is I have paraphrased. And you will see that in the actual section. Let me just get there again. In the actual section, it says treated or punished in a cruel, inhuman, or degrading way. I have left out cruel and I've left out treated because the question is about punishment. So I have only included the word punished. I haven't said treated. So, but if you include treated, it won't be wrong. Okay, any questions on this? I see we are already at 3 o'clock, so I don't want to keep you unnecessarily long. And then next week, we will look at more of the examples. So you will see that in the PowerPoint, there's a couple of examples for you to do. So please go and do those examples and come with them next week to the session when I will go with you through them and we will look at their answers. And then also, I will also go with you through some of the subordinate legislative documents that we have in statutes and that we are going to use. Okay, before we go, are there any questions for now? You can raise your hand if you have a question, please. No questions? Oh, no, yes, you may ask.
I'm sorry, ma'am, if you already spoke about this, but could you maybe please explain assignment B1 and what we need to do there? I don't know if you explained in the beginning of the session. We couldn't connect nicely.
Oh, shame. Okay, sorry about that. No, I haven't discussed it. Assessment B1 is basically 10 true and false questions, and I would recommend doing them after you have finished working through the entire study unit 1. Or you can even wait until after next week's contact session if you want. 5 of those questions will be based on theory, and then the other 5 will be questions like the ones that we have done just now. But they are true and false. You won't have to write the citation, but you will have to look for the answer in legislation. I don't know if that answers your question.
Yes, it does. Thank you, ma'am.
Okay, cool. Okay, any other questions? All right, then thank you for joining me, and then I will see you again next week. In the meantime, if you struggle or if you have a question, please send me a WhatsApp. Bye-bye, everyone. Enjoy the rest of load shedding.